Sir, you have to increase the volume.
Honorable Justice V.RAMASUBRAMANIan, my friend Orgo, ladies and gentlemen, thank you so much for attending this program. It's always a pleasure to be back at Chennai International Center. Well, the Ganesh Chaturthi holidays were spent reading the Colonial Constitution. As Orgo said, I have great allergy to this constant reference to colonial legacy, colonial this and colonial that. I would not call it a colonial constitution. I would call it an international constitution. And why do I say I would call it an international constitution? Because first of all, nobody foisted this upon us. It was our choice. And if you see the Indian Independence Act, in fact, Pandit Nehru said that we will not accept anybody's constitution. We will write our constitution ourselves. We don't want anybody else to write the constitution. Initially, that was not accepted. Then I don't want to go into this Cripps mission and so on and so forth. Finally, when the Indian Independence Act was made, I think Section 8 or Section 7 says that the Dominion of India and the Dominion of Pakistan will make their own constitution. Of course, by that time, the Constituent Assembly had already started. The Muslim League boycotted it, as you know. And then after the midnight of 15th August, the Constituent Assembly reassembled and they continued. We all know it's an indirect election, how people were elected indirectly and so on. But why I say it's an international constitution and not a colonial constitution is the Government of India Act came in 1835. And if you want to study, you must start with the Government of India Act of 1800 and how it went on and on and on. You had the 15 Act, 19 Act, and finally the 35 Act. As more and more the freedom struggle moved on, and people's aspiration was to get more independent, finally they decided to have the Government of India Act. It is a very well drafted act in the government for the governance of a complex state. Let us also not forget that the Government of India Act basically covered only 28% of the territory because most of it were princely states. But nevertheless, it covered what was called the Governor's provinces and the Chief Commissioner's provinces. And this was the Government of India Act. Now, if you see the debates, why I say it's international was, you had an act which worked for 11 years, from 1935 to 1946. As Orgo put it, that you had absolutely, as you say, when you read the roll call of people who were in the Constituent Assembly, it is absolutely, we feel very proud that these were the intellectual giants were there. Sir Aladi was there, Gopal Seva Iyengar was there, Kamath was there, Kunzru. Then you have so many other names which I keep seeing when I read all these debates from time to time when it comes to a case. And it will not be fair to say that, strong to say that the intellectual capital that was contained in the Constituent Assembly has not been matched ever since in our independence. Let's face facts. Now, and if you see the menu, the so-called menu which is given by Sir B.N. Rao, and he sends a questionnaire, and he leaves it to you. He says, look, what shall we do? Shall we have the presidential form of government? Shall we have this? Shall we have that? And then in the menu, if you see, he has given, this is the position in Ireland, this is the position here, this is the position here. And based on this question, ultimately the constitution was drafted. And if you see, the reason I call it an international constitution, and I don't like the word colonial constitution, is that this is an amalgam, not only from the Government of India. See, the Government of India gave us the governance model. They said that there's a union, they what they call the federation, then they got the provinces. They had the three lists between the federation, the province, and the concurrent list, which ultimately came from the Canadian Bainey Act, and so on. But when they drafted the constitution, you find debate after debate. When it came to fundamental rights, they took it from the American Constitution. When it came from directive principles, it came from Ireland. When it came to some parts of the emergency provision, it was from the German Constitution. So these are all the way, the amalgamation, they came and they made it. Now, the book says that they did not take into account certain Gandhian principles which were there. I have my doubts as to how these Gandhian principles could have been adopted. Then I further say that you say that they didn't take into account the village model, the panchayats and so on. But we ourselves introduced the panchayat model in part 9 in 1993. The municipalities came 6 months later. But if we don't implement the panchayat and municipalities, what is the point in blaming the colonial constitution? They never said that don't have a panchayat. We decided to have the model. And of course, there are debates which say that keeping in mind the period at that time, when Pahad Ganj you mentioned, the riots, the partition, the Holocaust of partition, all that was in the background. And in fact, when you see Sardar Patel's exhortation to people not to object to 370, they said it's a temporary thing. Please let it go because we are coming to such a position. Similarly, his very, very passionate plea of giving the princess the privy purses was also very, very important. So all this ultimately came into the constitution. So I would first of all say it's an international constitution. One thing I liked about the book was, of course, as just Ram Sonam pointed out, this Hindustan concept. In fact, I have not had the chance to read the 2 volumes of Vikram Sampath's book. My wife has been telling me to read it. But I was very surprised to see that this is what I must compliment him on the enormous research that has gone into this slim book. What was very, very touching to me was the treatment of Dr. Ambedkar in Baroda. My in-laws lived in Baroda, so I got married there and my children were born there. And I used to keep going to Baroda for so many years. At that time, my father-in-law told me that Maharaja Sayaji Rao was supposed to be a very enlightened ruler. And I think his Diwan was Sir Madhav Rao was his Diwan, if I'm not mistaken. He had a system of sending people to scholarships. And it was his scholarship that took Dr. Ambedkar to Columbia University. And if you read the Mandal judgment, in Justice Jeevan Reddy's judgment, he quotes certain passages that he wrote about caste and so on in 1912. Fascinating. And I was told by my father-in-law that the system was so abhorrent. I mean, just please read this book. It really gives you goose pimples or makes you shocked that something would happen like this. Nobody would give him a house. He had to stay in a Parsi house by taking a false name. When they came to know his real thing, those Parsis asked him to go out. This was the kind of system. And the only analogy I could see is, if you read the biography of Powell, who was the first African-American Secretary of State, after Colin Powell, after passing from West Point, which is a premier institute, he would not get housing accommodation in the US. And ultimately, of course, he became a 4-star general and then became the Secretary of State. But this was the point. And I remember almost 30, 40 years ago, somebody told me a story of Dr. Ambedkar in Baroda. I believe that he was an officer in Baroda, but the clerk, who was a caste Hindu, who would throw the file like this. They would not hand over the file to him. That was the kind of treatment they had. And I believe he remarked tongue-in-cheek and of course, the shocking thing was, I never knew, but thanks to Orgo, ultimately he had to go and live in some park in Bombay because no housing would be available to Dr. Ambedkar. So you can just imagine the angst of the man and why the provisions he made for the scheduled castes and so on. But one interesting point in all this was, he remarked when the constitution was made, he remarked that, look, when people wanted the Ramayana, they had Valmiki. When they wanted the Mahabharata, they had Vyas. When they wanted the constitution, they had me. Meaning in all cases, there was no upper caste person who did that. That was a remarkable thing. And I particularly find, and those of you who are interested, just see his speech on the 4th November 1948, when he makes the speech justifying why it's a long constitution. And it is for the first time that he uses the word constitutional morality. So I think Orgo has brought out very well the origins of the constitution, how it came to be drafted. And I part ways in calling it a colonial constitution. But apart from that, that research is truly commendable. I'm also very glad that you did not say basic structure has to be revised, because that is now the most fashionable thing to do, you see. In fact, I had the privilege of delivering the P.Datar Memorial Lecture this year at Ahmedabad. And he was one of the greatest judges we had in the High Court. In fact, just to tell you a story, I had gone to meet Chief Justice A.P. Shah was our High Court judge. And there was a portrait of a person on his table. So I said, sir, is this your father? He said, no, this is P.D. Desai. And he said, this is the man I respect most. Yes. In Chamber had the portrait. And P.D. Desai was a Chief Justice of Gujarat, of Bombay, of Calcutta. But he refused to go to the Supreme Court because he was superseded once. And to the credit of the man, after retirement, he did tremendous work for the rehabilitation of the Narmada people, did not took 1 rupee a month salary and only took car and petrol to go from village to village. So that was the thing of P.Datar. Anyway, the point is when I did this P.Datar memorial lecture, I spoke on the basic structure. And I was surprised to see so many people. You mentioned about the old cloth. They said, look, Constitution is 75 years old. Is it not time to relook at it? Is it not a time to relook at the basic structure? And I asked the simple question, and I've asked this question in so many seminars and debates. From 1950, we have this Constitution. The basic structure came in 73 because you wanted to destroy the Constitution. And to the credit of the Supreme Court, it was saved by 7 judges out of 13. And I at least hope in my lifetime, we don't have a situation where a bench of 15 is constituted and 8 people reverse it and we go back to the place. It's very simple. You just require 8 people to tilt the balance and go back to old days. But these 7 people say the basic structure. And when I attend so many seminars, the standard thing is must have a relook. Companies Act has become old, relook. Income taxes have direct taxes scored. You keep on having these things, but ultimately at the ground, nothing really changes. Now, coming to this colonial constitution, what I wanted to mention, because we're going to have a panel discussion also, I just wanted to mention that not one person has told me so far which provision of our constitution is an impediment either to economic progress or to social progress. Nobody is able to tell me so far. In fact, we had the right to property that was taken away. And as we'll discuss later, preventive detention he mentions in the constitution, very unique. This is the only constitution which has preventive detention as a part of the constitution itself. And there's a lovely passage, part of fundamental rights. And if you read the A.K. Gopalan's judgment of Patanjali Shastri, I knew the passage by heart, but I forgot it now. Patanjali Shastri, they say, how can you have preventive detention in a chapter on fundamental rights? It is a paradox. It's a contradiction in terms. But Justice Patanjali Shastri puts it beautifully. He says, this sinister provision, so out of place in our noble constitution, is doubtless necessary to meet the problems of the day. Because at that time, my grandfather told me there was so much of communist movement, labor unrest, partition problems, caste problems, and so on and so forth, that this constitution was necessary. I'll not go further. He also mentioned about fundamental duties, kartavya. Now from Amrit Kal, it's become Kartavya Kal. And as why are we trying to emphasize on duties? Is it because you want to tell people that don't emphasize on your rights? You're going to have lesser and lesser rights and you're going to have more and more duties. I don't know what is the objective of saying that. And I'm rather, I don't know if there's a pattern to what is happening around, India and Bharat. I wrote an article in India Today on India and Bharat. Now there I want to mention that this question of Bharat, you either say Republic of India or say Bharat ka Samvidhan, Bharat ki Ganarajya. You don't say the Chancellor of Deutschland, you say Chancellor of Germany. So my point is, it should be, if it's Indian, keep it as an Indian name, Bharat ka Samvidhan. As I said, in the constitution, the word Bharat comes once. There are 550 times India used, only once Bharat is used. Go to the Hindi version, India is used once, Bharat is used 550 times. So don't mix up the two. And that's again my problem with this IPC, CRPC and if you want to have an English law, keep an English title. Don't put Bharat Nyaya Samhita, just call it Indian Penal Code. That's my basic problem. So when you talk of the colonial constitution, the way to reject this colonial thing is not by changing names from Trivandrum to Thiruvananthapuram and so on. The problem is to solve greater problems. And Orgo said that, I'll just, like Justice Ramswaran said, I have the same thing. I try to see the first and then I see the end and I see the acknowledgements in the book. Unfortunately, since I write books, I don't have the liberty of seeing only the conclusion of the judgments. I have to necessarily wait to 180 pages of decree. Yes. But I'll just mention one thing, Orgo, and I'll conclude. You mentioned that this is not a call to draft the new constitution. That was a very, very heartening thing. And he said that it's time to think about the constitution. My suggestion is, let us devote only 10% time to think of the constitution and think of 90% time how to solve the problems within the framework of the constitution. If a company is doing very badly, then the solution is not to amend the memorandum articles, check the management of the company. Thanks.
So thank you. Thank you very much, Justice Ramasubramanian, Mr. Datar. I think the organizers now have many ideas for future seminars in Mr. Datar's speech, basic structure, names changing, but I think we can keep some of that out today. Since we've spent a little bit of time discussing the origins of the Constitution, and both of you have operated the Constitution on a daily basis, almost as lawyers and judges of our superior courts, I'd like to take it to one or two issues that we deal with, that I deal with here, and then open it up for questions, given the paucity of time. So first, I'd like to come to one part of the Constitution, Justice Ramasubramanian, that is fairly overlooked and seems today like an anachronism, which is the directive principles of state policy. At the time of the formulation of the Constitution, it was a fairly novel idea because constitutions deal with only political democracy. Here was an idea of how India would be an economic democracy, whether we agree or disagree with the direction that was taken. But in today's day and age, as written in another newspaper column where I have to pay 85,000 rupees per month for my 2-year-old son's Montessori school, and it costs 2,000 rupees to get a haircut at a salon. We have a constitution that in the preamble declares us to be socialist, and also in the directive principles chapter that calls about material distribution of resources for the common good. So how do you see this directive principles chapter as having aged over time, particularly your experiences in court?
No, but actually, at the time when the debates took place, they divided this into two types of rights. One, justiciable rights, and another non-justiciable rights. If nobler objectives dictated the preamble, the pragmatism dictated where it should be incorporated. If the rights contained in the directive principles of state policy had been made part of the fundamental rights and became enforceable in law, the state would have had to share a huge financial burden, which they thought it was not possible. In fact, this Veer Savarkar's, you have mentioned the draft constitution, he has made all these rights enforceable in court. Because nobody asked them a question, how will you do it, where is the money? Because if I am not going to operate the constitution, I can really say anything I want. Like freebies. That's right, freebies. See now, but over a period of time, the courts have come to the rescue of citizens by tweaking some of the directive principles of state policy into fundamental rights. For instance, how did we get Article 21 capital A? So that was, so therefore by a proactive measure, this is one of the things that I used to say that courts have also done some good things. So Mohinigiri, Article 21A came. So slowly through a back door, what was not let in through the front door was let in by the court through the back door. Because we were expert in.
So would you like to add anything?
No, I would just tell just Ramasubramanian, the courts have done a lot, and there's no doubt about it. In fact, I keep telling people that if 80,000 writ petitions are filed in Madras and Madurai, it shows that for the vast majority of people, the judiciary is the only place where they can go. And I can say that in practice, courts have been very proactive in trying to implement directive principles. You mentioned about 21A. And not only that, I think they have also read 21 into many of the directive principles are brought in as a facet of life and liberty, environment, minimum wages. Though they are part of directive principles, they have said that right to wage is part of life, part of liberty, and so on. So that way, a lot of implementation has taken place.
But actually, that's a very interesting point, because if you also see the founding of the Constitution, as Justice Ramasubramanian was saying, that they were all part of one large chapter, and this separation into two chapters happened later. And it was interesting that one of the things that was listed as a non-justiciable principle in the first draft was equality. was what we know as Article 14 today. That was actually seen as a non-justiciable directive principle. Patel said in that advisory committee on fundamental rights that equality is so central that we have to bring it here. I'm not listening to the lawyers. I mean, he himself was a lawyer, but I'm not listening to the lawyers in the committee on this one. So that was that was interesting. But one place where the lawyers did have their sway, Mr. Datar, is in relation to Article 21 of the Constitution, life and personal liberty. We know the whole story in relation to Justice Frankfurter and why we ended up with the word reasonable procedure established by law and not due process of law. Now, we know that this essentially, and particularly for those who are not from the legal fraternity in the audience, what this has allowed is the state, in some sense, to pass several laws that restrict liberties of citizens. And this is across party lines, that there has been no government that wants to get rid of a provision like sedition. No government, irrespective of which party they belong to, because the Constitution does sanction it. And the judgment of the Supreme Court in Kehar Singh upholds that. So the question that arises is that in terms of life and personal liberty, so you can go for life and personal liberty, the difficulties of getting bail on an everyday basis in court, the number of cases that you find where policemen are slapping cases of sedition or other unlawful activities under the UAPA. How much do you think that this is attributable to the fact that we have large leeway that is given to the state under Article 21, and how much of it can we attribute only to some malevolence of a local policeman?
Very interesting point is that in the ADM Jabalpur case, they said that you can't approach the courts at all. Even if your rights are taken away, you can't approach the courts. Of course, they went one step further and they said that you can't even say that I've been detained wrongly under MISA. Now, in the 44th Amendment, they made sure that even in an emergency, you can't suspend the right to life and liberty. So the Constitution says that whether the country is in a state of emergency or it's in a normal state, your right to life and liberty is protected, enshrined, nobody can take it away. But the difficulty, what I find is that if Vidhi can make a study, we have more and more laws which permit preventive detention. As you mentioned, shockingly, I did not know it's 85 lakh people are detained like that. I don't know how much are through preventive detention, but yes, but when you study UAPA, when you study so many laws, while you have made Article 21 as permanent and inviolable at all, at the same time you have statutory laws which make it impossible to get bail. Now, I don't know of any country in the world which says that you can't get bail unless you can show that you're likely to win the case. This kind of provision is not known. And in fact, those of you who want to, a very interesting case on where I think I would, with all due respect, lay the blame on the Supreme Court for not going far and striking down these provisions which say that, I mean, we had this Vijay Mohan Lal thing where the PMLA was Vijay Madan Lal case where they have completely supported very, very draconian provisions. And I'll just give one example. It's a brilliant judgment of the Privy Council. Mauritius, the Constitution of Mauritius, Section 1 of the Constitution of Mauritius says, Mauritius is a republic governed by rule of law. That's all. They made a law saying that for narcotics and drugs, courts shall not grant bail. All right? That was challenged by the Mauritian court, struck down, went to Privy Council, struck down. You know on what ground? The Privy Council says, arresting a person is an executive function. To grant or not to grant bail is a judicial power which can never be taken away. If it's a country ruled by the rule of law, then the power to grant bail can never be taken outside the courts. But right from Kartar Singh and so on, we have always, you see, on the excuse of public interest, terrorism, etc., we have tried to. So on Article 21, my point is, it's a paradox that though the Constitution makes it sacrosanct, our own local laws have slowly and surely eaten it away and made it more and more difficult to get bail.
So I think that's a good segue to talk about the future, because I think we've discussed the origins and also the operation. Maybe a word about the future, because this is something that I haven't dealt with in my book, as Justice Ramasubramanian pointed out, and I've only given some hints of where I think it could go. of course, this has much to do with the memorandum and articles and not the management. I think we have many discussions about the management of the company. But I think on the memorandum and articles themselves, and Justice Ramasubramanian, I'd like to ask you, since you are, if not the most knowledgeable person I know about in the legal fraternity on ancient Indian culture
See,
and history.
I said you are very knowledgeable. You are exposing your ignorance. Sir.
Is that how do you see ideas, particularly ideas in relation to duties coexisting with rights? Let me put it simply, because I think no one's case for a constitution that has duties is to say that there will be no rights. I don't think that is a case that can be made, and that is a straw man. So how do we see the idea of duties within a constitutional framework?
See, the difficulty with duties is, where do you enforce them? We are not able to enforce duties upon our own children. Teachers are not able to enforce duties upon the students. The society has come to a stage where, each individual has become an island. The enforceability of duties upon individuals, whether it is personal duties or social duties. We have, after all, social contract theory. All of us live in a society where each one, owes something to the other, and the question of coexistence is. But enforceability may be a problem. In fact, in one of the seminars, somebody asked me, the Constitution has become bold. I said, all right. Has become very bold. I said, it's all right. Let us. I am prepared to select five of you, appoint you as the drafting committee. You come up with a new constitution. Then they never turned up for the meeting. So the task is actually difficult when you sit down to pen details. When ideas are, mind is very fertile. It comes up with a lot of ideas. But when you pen down all of the ideas into real, you provide a structure, it becomes extremely difficult. So my problem is Gandhian ideas were good, actually. But enforceability of duties, I don't think, where will you enforce them? Courts are not the places where, to some extent, courts can penalize an individual. For instance, you have this Maintenance of Parents and Elders Act. If properties are taken away by the parents, and then parents are not maintained, parents go to court and get back their property. That is not a way. That is not the way of enforcing the duty upon the children. It's one way of penalizing or, getting back what they lost. So this is a very, very tricky area.
This question of right and duty is, in the Hoffeldian sense, you say that every right has got a corresponding duty. Maybe what they say, I just think that when you say I don't want to get into fundamental duties. I have still not understood why Swarang Singh committee recommended fundamental duties. It's like telling a child, you shall do your homework, you shall do this. We know that. You don't have to tell us. But fundamental duties is a chapter in the Constitution. But what right and duty, perhaps I think it's John F. Kennedy who says that the right to free speech carries a corresponding duty to think before you speak. So maybe in that sense they say that if you get a right, then before you exercise that right, you have to have a duty to think. So
really think they won't talk.
yes. So maybe in that sense, the right-duty correlation could be important, that with great freedom or with a large amount of rights also carries a corresponding duty to think about those power, how you exercise it and so on. I don't know if you can think in those terms.
One area where probably this can be developed is the area where we have civic duties. See, for instance, in Singapore, we all talk about Singapore being clean. You can't throw anything on the road unless you invite a penal consequence. Here, the whole country is, we treat it as a dustbin, except our house. Other than my house, all other places are dustbin where I can throw everything. Though that is probably where the duties can, I'm not able to immediately visualize any other area where duties can really be enforced except through penal provisions.
So one last question, Mr. Datar, and then we'll open it up. Because Justice Ramasubramanian mentioned that how difficult it is to actually be a new drafting committee, but it was tried with the National Commission to review the working of the Constitution, headed by Chief Justice Venkatachalaya, a very eminent body, was set up in order to do this task, and they made a whole range of recommendations. But of course, even at that time under Vajpayee's government, there was not enough consensus across the board, so that that project was shelved. Now, and there were many recommendations made, particularly, as you know, on topic we were discussing before on judicial appointments. There was a recommendation made. There were interesting recommendations made on right to recall elected representatives if they are not performing, which is I think an idea whose time has come. But be that as it may, so if there were to be a body with the person of the eminence of Chief Justice Venkatachalaya, as in what are the things that you think are things that are worthy of rethinking because it's 75
Yeah,
years?
I think first thing rethink is the 10th schedule on this. In fact, the 4th November 1948 speech of Dr. Ambedkar uses for the first time the word constitutional morality. And we talk of constitutional morality. In fact, I don't know when the Chief Justice is going to constitute the Sabrimala bench before 7 or 9 judges. And I think we have divided the work, and it's my lot to argue on constitutional morality. 10th schedule is a classic case of constitutional morality. You had this ARGHYA thing where people would wholesale defection, so that was checked by 10th schedule. Now, they never contemplated that within one party there will be a defection. So the original party, parliamentary party, that's one area. Second area which I was thinking about what needs to be done is Article 282, where they say that monies can be spent only for public purposes. And that's a big problem on freebies. You see, Mr. Shivaraman is here, he's been, I think one thing which will really, really hit us badly is this thing of giving endless amount of freebies. You just can't sustain it beyond a point. What happens is you govern badly, and if you want to come back to power, only thing you can do is I'll give 2,000 rupees free to a lady, I'll give 4,000 to a child, give 1 lakh for a laptop. It just goes on. I argued very unsuccessfully before the Supreme Court in that Subramanian Balaji's case that free laptops, free thalis, free this, free that. And I said that there's a 3 US Supreme Court judgments which I quoted, they didn't follow it. They said that public funds can never be used to create private assets. You can use one computer center, make it for the schools, make it for the community, but you can't say I'll give free laptops, this and that. So I think Article 282 can be amended. I also want to say that giving such freebies should be taken as a corrupt electoral practice. Otherwise, I think we are going to go into, if you just see the statistics, go to the website of Telangana, go to the website of Karnataka, the only achievement of the government is how many free things they are giving to everybody. And it's also frightening. We have got, 140 crore people. But as per the latest website, I saw that 88 crore people are going to get free food grains. Now you talk of old shirt and old clothes. After 75 years of the Constitution, if 80% of a population has to be given free food, then it's a very serious matter of concern. So I would say 10th schedule, I would say Article 282. I would bring back the right to property, not put it in 300, put it back into Article 31. Yes, these are the things I would immediately do. And as far as the judiciary is concerned, I would put the collegium in the Constitution itself.
Again, that's another seminar that we can have. But let's have questions. There are many people here. Let's have questions.
Yes, you quoted the preamble as having the word socialist. So till now, I have seen 2 to 3 enlightened and highly intelligent people questioning the socialist and communist ideology because they have been put under concentration camp, like what Hitler did in Germany. There were communist concentration camp, which one highly enlightened person suffered. And second is the question of Tibet. You quoted Morris Friedman. Morris Friedman was in favor of giving independence to Tibet, but eventually that was taken out. So these, the 2 people that, one of them is Ayn Rand. There was a person called Ayn Rand. She questioned the ideology of socialism and communism and publicly told that it is a wrong ideology, but still our country follows that ideology.
Your question.
So how can you justify socialist word included in the constitution? I find no justification and it is very wrong.
Any freebie that is announced, it's clearly unconstitutional because you're preempting the appropriation act that should be passed by the legislature or the parliament later on. And these people, if they announce the freebies, they have already passed the budget. How can they do? I followed your arguments at that time, and I wrote to the election commission also that you must take a firm view on this. You must prohibit these freebies being given because you give the freebies without any resources in sight. You are destroying the basic structure of the government itself.
Yeah. In that case, the court, and I have put with this Sadashiva and Justice Gogoi. So in the freebies matter, it was a bench of Justice Sadashiva and Justice Gogoi. And in the latter part, he recognizes that these freebies are vitiating the election, that it doesn't become free and fair anymore. And the matter was adjourned for some time to ask the election commission to see if they can pass something. They came back with a reply saying, unless all the parties agree, we will not do it. No party is going to agree. I think they should amend the law and ban it, or at least, then they asked, I said, you can keep the below poverty line, say basic, say 2 kilos of rice or something, that's perfectly fine. Yeah.
So that socialist point you want to...
No. On socialism, this was added by the 42nd Amendment. Secular and socialist was added in the Constitution, apart from various amendments. After the emergency, when Janata government came back to power, the 45th Amendment wanted to delete secular and socialist and also delete various other provisions. But Janata government did not have majority in Rajya Sabha. So the Congress said, we will not pass this constitution bill unless you agree to retain secular and socialist. So they retained secular, socialist, and tragically they retained the chapter on tribunals. These three provisions Congress insisted as a bargaining thing to allow the 44th Amendment to go. So that's how secular socialist has been retained in the Constitution. Because Congress refused to permit it.
I have two short questions. Two things have intrigued me about the creation of this Constitution. One is, why was Mahatma Gandhi not consulted at all? Because as you rightly said, one answer would be that the Constitution came into effect in the 1950s and Mahatma Gandhi passed away in 1948. But as you rightly pointed out, in mid-1947, there was a draft available. So why would somebody not take a draft constitution to the Mahatma and ask him, what are your thoughts on it? Because his thoughts on it are what Justice Ramasubramanian said to the state of Aundh, where the king was called Bala Sahib. And he actually donated the entire state to his people and said, come on, go ahead and govern. In the constitution that is drafted, two things stand out. One is decentralization and the other is Panchayat Raj. Now, having expressed his thoughts on what a constitution would be, I'm very intrigued. Nobody went to him and consulted him on that. That's point one. Number two is, in the great research you have done in bringing out this book, why is there no mention of a political party in the constitution that was originally conceived? Till we had the 10th schedule, entire democracy rests on the foundation of political parties. And it's not as if political parties were alien, because we have already conducted elections with political parties. But the word political party does not figure at all in the constitution till the 10th schedule came. So these two have always intrigued me.
Sure. So I'll take that. On the first one, actually, I deal with it in quite a great bit of detail in the book itself as to why there's this absence of Gandhi in the constitution. I think it's a very complicated set of reasons, but to put it very simply, is that by the time we get to 1946, Gandhi himself is not that interested in a constitution. He is actually much more interested in ensuring that there's communal harmony, that the nation stays undivided. And he says, and he goes on record and says that the constitution is a mere policy document. A son cannot follow their father as a matter of policy. He said, I am only interested in making sure that we have good sons in India. So he is not interested as much in the framing of the constitution, number one. Number two is that, but you can still ask, what about Gandhians in the assembly? There are so many Gandhians in the assembly. Now, basically, again, to cut a long story short, the Gandhians in the assembly wake up very late to the fact that there is no Gandhi at all in this constitution. When they have woken up, not only has a first draft come from Benegal Narsingh Rao, Ambedkar has worked on the draft, there is a full draft that's there. And that is why I write in my book that I find it shocking that a freedom movement that is based on non-violence and satyagraha, the constitution doesn't use either of these words or their spirit even once. It doesn't use it. Because by the time they wake up, this draft has happened. So what happens then is actually something curious. Is that if the Gandhians say that no, it cannot be like this. So some ideas have to come in. So where do they come in? In directive principles. As prohibition, prohibition comes in, the village unit comes in the directive principles. Cow slaughter, prevention of cow slaughter comes in, and then TTK makes a beautiful statement, is that he's become a dustbin of sentiment. He says it's become a dustbin of sentiment so wide that everyone can ride their hobby horse into it. Okay, so this is what happens to the directive principle. So that's what happens with Gandhi. He himself is not that interested in the constitution by the end of it. And as far as the second question on political parties, as in the cynical answer would be there was only one political party. I think no one envisaged really many political parties.
In a lighter vein, I used to say, yeah, time will come when 10 schedule will go away. You know how? A political party will, with huge financial resources, will not nominate candidates to contest elections. They will sit on the fence, allow people to contest, and they will buy 350. A much easier option. Nobody has asked me.
A question there, please.
Yeah, first of all, thank you very much. It's been absolutely fantastic event for me. I don't live here, I live in Hong Kong, and to come here and thank you, ma'am, thank you, sir. The reason that we had such people of high quality wisdom who got together to write our constitution, is that the reason not to put anything in the constitution regarding what sort of people should be standing for elections and get elected as our representatives, or shall we do something about it?
Well, maybe you have to first come back to India and become a voter. Yeah, that is basically the electorate. So actually, this is a very interesting point that you mentioned, because one thing that I think is actually a remarkable feature about the Constitution is that they do away with all kinds of requirements of franchise. That every single adult, irrespective of literacy, irrespective of education, can vote. Something that was not even prevalent in the United Kingdom at that time, let alone the United States. And that is something that everybody in the Constitution is ad idem on right from the get-go. And I think that's impressive. The second is that so recently there was a judgment of the Supreme Court in the case of Rajbala, which was given by a bench of Justice Chalameshwar and Sapre, where there were restrictions in relation to who could stand for elections in local elections in Haryana. And there were three provisions that were put. One is that you should not have any dues on electricity bills and so on. So whoever stands must not have any dues to the government. Secondly, you must be a class 8 pass if you were a woman, and a matric pass, I think, if you were a man. And you must have a pakka toilet in your house. These were three restrictions that were put on who can contest elections. And the Supreme Court, in my view, rightly upheld those grounds by saying, and there were many arguments made that there are no restrictions like this for members of parliament and legislative assemblies, but there is a rational nexus. One, that you have to be a good citizen, and two, the fact that you have to have some basic level of literacy to be able to represent your constituency. So I think that as far as limitations are concerned, as I've always said, that I think we should not go down that path, as we are only as good as the people we elect, and we must hope that we live in a polity where people become more and more responsible.
We have a question here.
Yeah, thanks so much. It was a wonderful discussion, as you just said. And regarding the meritocracy argument that he was talking about, if I can just briefly say something before I ask my question. I would refer him to this book, The Tyranny of Merit by Michael Sandel. So this whole idea of meritocracy, I think he questions that, and perhaps you
Not talking about meritocracy, he's talking about barring people with bad antecedents from contesting elections.
Okay. But I thought that who would be qualified to contest? Not. Yeah.
Who would be disqualified?
Disqualified, rather. Okay. Regarding the other interesting discussion, I have 3 points to make. One is about, you spoke about directive principles, and interestingly, Article 44 was not mentioned at all. So I wrote an article in the Hindu on this and said, in fact, why not rethink this article itself? Perhaps even consider repealing it if possible, because from the time it was enacted till today, it has never been implemented, or even no draft has also been produced on that. So, which means that no political party has been able to even produce a draft. It means it's absolutely difficult. Although it was made in good faith and with a good intention, it would appear now that this is impracticable and impractical. So therefore, maybe there should be some rethink on that. The other part which I wanted to ask you was the colonial word that you used in your book. Perhaps what you actually mean is the authoritarian streak in the Constitution that the Constitution enables. I think it was beautifully exploited. The First Amendment, when it was presented in May 1951, the most vehement, strongest argument against it was by none other than Shyama Prasad Mukherjee, the founder of Bharat Jansangh, from which came the BJP. So interestingly, it was S.P. Mukherjee at that time who said that, who completely attacked Nehru on this First Amendment, and said that, what if Congress is not in power and somebody comes and uses it? And I think we are seeing that today, in a sense. So it was, interestingly and ironically, if you can say that, it was the founder of Bharatiya Jansangh which flagged this issue and said that this is where authoritarianism will come through into the country. So maybe you would like to say something on that. And if you can just add one more thing regarding the safeguards, as a minority, as a Muslim, lot of safeguards were there for the Muslims in the Constitution. I mean, before India became independent. For instance, separate electorates, and Jinnah was also demanding proportional representation if that was not possible. But all these safeguards were taken away. And interestingly, a recent book by Prathina Vanil alleges, a book called Another India, alleges that most of, or almost all, the Muslim members of the Constituent Assembly were literally handpicked by Patel and others, so that they would rather simply succumb to his demands. For instance, he calls Begum Aziz's Rasool the poodle of Patel, where, for everything that was that should have been there as a constitutional safeguard for the Muslim was simply done away with. The Constitution didn't do anything. Ambedkar, who himself was demanding separate electorates for the Dalits, he didn't say anything about, because all these things were there before the Constitution came into effect. All these things were done away with. So why do you think this happened? Was this, are these things, do these things also constitute something of the colonial mindset that later on came back? Thank you.
So just in very short, as far as the first point about the Uniform Civil Code is concerned and whether we should remove that directive principle, as I think that there needs to be a draft that is done. We ourselves, as a few colleagues and others, have put out a draft of model family law reforms for discussion. This is not an issue in relation to backward practices in one community or the other, but it's actually a question of what modern family law in 21st century India should look like. So even the Supreme Court, which is going into this question of gay marriages, whatever it decides, and it can decide whichever way it wants to, the fact is that it will make no difference on the ground unless there is something like a code of this nature. Which exists. So I think I would go the other direction. I wouldn't say that we should scrap it. I think we should make some effort, which was not made at the time of the drafting of the Constitution, though everyone was saying in favor of the Uniform Civil Code. No effort, no one ever saw a draft. So I think we should go in that direction and try and think up a draft that is genuinely workable in 21st century India. So that's number one. Number two, on the question of the First Amendment, as in I don't deal with it in the book itself. There's an excellent book by Tripur Daman Singh called 16 Stormy Days about the history of the First Amendment. And you're absolutely right that the First Amendment actually really opens the floodgates to the constitution becoming a pale shadow of itself. And I think that it's an act of great irresponsibility at that point of time because of some political compulsions, two political compulsions. One was the judgment in Champakam Doriarajam's case, which was a political compulsion out of a communal GO in Madras. Yeah, and the other was that Romesh Thapar and Crossroads and Brijbhushan and the RSS magazine, the mouthpiece organizer, and third was this right to property. But the point is that irrespective of any of this, the fact is, and I go back to what Chief Justice John Marshall had said, that this is not an ordinary law. It is a constitution you are expounding. So it's very critical to understand that political expedience should not mean that we can think of amending constitutions at the drop of a hat, but that was the precedent that was set, and that is what has happened. On the last question on separate electorates for Muslims and other safeguards, this is a much longer conversation. I think we'll just have it offline.
Only, he has already mentioned about the First Amendment, which I mean, I cannot justify the 9th schedule where you put something and it can't be challenged. It's, you know, and it's interestingly, if you read Daniel Austin, this was the idea of VKT Chari from Madras, you know. So, but on this question of minorities and so on, I don't want to say Muslims or let's say all minorities. It's not correct to say there is no provision. 2930 are special protections for you, and Article 15.5, which I argued against and we lost for Justice Patnaik, was that all education institutions of minorities have no restrictions. You don't have the Right to Education Act. You need not admit students. 25% need not be admitted. So I don't think it will be a stretch to say that all the protections of minorities are gone. In fact, there are a lot of protections still there in this matter.
That's it. So we come to the end of this very, very interesting. We pride ourselves at the CIC that we are a spa for the mind and the soul. And I think today's discussion really opens up a number of subjects which can be debated, and we are thankful to the erudite panel to really have gone into areas which others might have dreaded to tread into. Well, whether it's an expedient constitution, colonial constitution, or an international constitution, I think you'll all have to read the book and form your own conclusions. But we at the CIC are very privileged that we had this conversation here, and we had this erudite panel to really discuss and go into all these aspects. I'm sure all of you would have enjoyed this conversation, which really went into very fundamental issues which need much more intellectual debate and discussion. And we hope to bring such debates and discussions in future too. So thank you very much, sir, for joining us, and we hope to see you all more often in other events of CIC. Thank you very much.